The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Please be seated. Glad to have you with us and glad to be back here in Richmond. We're happy to hear argument in our first case, Williams versus Kincaid. Mr. Ulrich, whenever you're ready.
Good morning, and may it please the court. I'm Joshua Ehrlich here on behalf of plaintiff appellant Keisha Williams. Ms. Williams is a trans woman who has lived her life in conformance with her true gender identity for nearly 20 years. As a legal matter, she holds a Maryland driver's license that identifies her as a woman. She's received a legal name change and a legal change to her gender markers. The Fairfax County Adult Detention Center, the jail run by defendant appellee Kincaid, classified Ms. Williams as a woman, assigned her women's garments, and placed Ms. Williams with the female population until nurse practitioner Wang changed that classification. While in custody, Ms. Williams faced mistreatment and discrimination from employees of the sheriff's office. She timely filed suit against those individuals, and we worked collaboratively with defendant appellant's counsel to learn the names of those individuals that she had identified in her complaint. Rule 15 states that relation back applies if a complaint is served, quote, within the service period provided by Rule 4M. Ms. Williams met that requirement. Defendant appellees consented to and Judge Hilton ordered an extension of the 4M period, and the amended complaint was served within that extension.
Counsel, can I ask, assuming hypothetically I agree with you that the service here was timely, and the district court erred in applying the limitations period, what should we do? Vacate and remand and let the district court consider all of these claims against these two defendants in the first instance?
Yes. There are two sets of issues here in that context. I think that Ms. Williams clearly pled a claim if you consider all of the allegations in the complaint, as opposed to omitting the allegations between November 16th and February 12th. Secondly, I believe that the ADA issues, which I'll come to in a bit, are different qualitatively, and that is something I think this court should look at regardless of the answer on relation back.
Well, I thought the ADA claims were only pled against Kincaid. Is that not right?
That is correct.
Okay, so there's nobody is arguing that defendant Kincaid is not properly in this case, right?
Yes, that is correct, Your Honor. I was just speaking to the two classes of claims.
I'm sorry, I'm not sure I understand your answer
Sure.
to the question, because I thought the question was, if we find, hypothetically, if we conclude that you're right about this, we send everything back. But is that your answer?
If you conclude that we're right about the relation back question,
Yes.
the gross negligence claims, the deliberate indifference claim, and the equal protection claim should certainly be sent back.
Just the claims against Nurse Wang and against Officer Garcia go back.
And the gross negligence claim against Sheriff Kincaid.
Why does that one go back?
Allow me to back up. I believe you are correct that the statute of limitations issue does not address the gross negligence claim against Sheriff Kincaid. That would be correctly placed along with the ADA as something that's not related to the 15C issue. I apologize for that confusion.
And related to that, aren't there even with, it seemed to me there were dismissals of some of the claims against Garcia and Wang purely on the statute period, but some were addressed that were within the statute period. Is there any reason we shouldn't address claims that were resolved by the court on the reasons other than the statute?
The only concern that I have with that is that the way that those claims were resolved involved omitting the exception of that. No, I don't disagree.
But what about, I mean, I don't know how much we need to get into the weeds here, but it sure seemed, and I didn't understand this, as though with the claims against Deputy Garcia, they all arise from the same search at the same time. I think it was January 2019. And on one of them, the district court said, that's barred by the limitations period, so that we would have to send back. I think that was the equal protection claim. But then on gross negligence, for whatever reason, the district court appears to have reached the merits. So would we review that, or should we still send it back?
I think you should still send it back, but I agree that it's a little bit unclear what the district court did there, because the district court said this issue, that it doesn't need to reach the merits on that issue, but then discuss the merits in any case. I think as a matter of pleading, it should go back so that even if the district court lands in the same place, it has issued an order based on the full allegations. Ms. Williams met all of the requirements for relation back under Rule 15, even if this court were to disregard the extension period, though. Nurse practitioner Wang and Deputy Garcia, through their counsel, which is counsel shared by all defendants appellees.
So I don't want to tell you how to argue your case, but
Yeah.
as I understand it, the defendant agrees with you on, I don't see the defendant defending the district court's reasoning. The defendant has a different argument about the statute of limitations, which turns on John Doe and mistake, but I don't want to tell you how to argue your case, but I sure do want to make sure we have time to get to the ADA issue today.
Absolutely. Very quickly, with respect to the John Doe issue, I'll just say that I believe our argument is consistent with the Supreme Court's ruling in Krupski and this court's ruling in Goodman v. Praxair, where the Supreme Court shifted the focus of the mistake doctrine and the relation back doctrine to the knowledge of the defendants and not the knowledge of the plaintiff. Rule 15 speaks to notice and prejudice. There is no reason to believe that there were any notice issues or any prejudice issues in this case. Defendant Appellees Counsel, which again is shared by all defendant appellees, were aware of the individuals we intended to name before the amended complaint was filed, and it's likely because of that Garcia and Wang had actual notice as well. But I'll move on now to the ADA. The Supreme Court ruled in Bostock that the language of statutes must be read as written, but considered in the context of the current day. While on the basis of sex was not necessarily written in the 1960s to bar discrimination against trans individuals, our modern understanding of those words necessitates that outcome. Similarly, we must apply a modern understanding of the text to the ADA. The exclusion of gender identity disorders means exactly what it says. It means that the ADA excludes certain disorders now rejected by the mental health community. Gender dysphoria is a new and different diagnosis which rejects the idea that being trans is a disorder and acknowledges that trans people can experience certain symptoms and distress arising from having a gender expression that differs from their birth-assigned sex. This court noted in Grimm v. Gloucester County School Board that being transgender had been pathologized for many years, and the DSM-IV begins its definition of gender identity disorders with a strong and persistent cross-gender identification. The DSM-V shifts that focus. It is no longer a question that being trans is a disordered identity. It is that people who are trans can have symptoms arising from the distress of having a gender identity that is different than their birth-assigned sex.
Counsel, are you required to talk about the dysphoria generally, or are you required to plead the physical elements or pathological elements with respect to your client?
Miss Williams pled broadly with respect to including things like the WPATH standards. But from a pleading perspective, certainly we can't plead just the existence of a condition. We have to plead specifically for our client. But I believe that we did that here. Among other things, we pled that Ms. Williams has gender dysphoria, that she's been long diagnosed with gender dysphoria, and that she's been on medicine for gender dysphoria in the form of hormone treatments, a daily pill and a twice-monthly injection for 15 years.
So, and to the point you made just earlier about how we look at the statute and the exception that we're dealing with, I appreciate your argument in reference to Bostock about a modern understanding. Would you agree that if we consider the text of the statute at the time it was entered, the exclusion would apply?
The text of the statute at the time...
The understanding, the meaning of the words in the statute at the time it was enacted.
I think the answer to that is yes, based on the case law at the time, because, among other things, one of the things that the exception in 12211B did was it took away the disability protections that trans individuals had for the previous 20 years prior to 1990 under the Rehabilitation Act. So at the time, I think that that's the case.
The last question I have on the ADA, and I'm sorry to ask so many, but is it your contention that the gender dysphoria your client experiences is a physical impairment?
Yes, it is, Your Honor. First of all, with respect to the question of impairment specifically, the Department of Justice filed a statement of interest in the Blatt case. And they explained that according to the case law and Department of Justice regulations, impairment just means a physical condition affecting one or more body systems, including the neurological and endocrine systems. Impairment is not a synonym for disability, such that you have to plead disability to get to disability. Impairment is quite a low bar. And with respect to Ms. Williams, we've pled that she was on hormone treatment. Hormone treatment is for the purpose of addressing a physical problem with the endocrine system. In addition to those things, the amicus brief filed by GLAD speaks in depth on some of these issues, and I can refer you there for some further.
No, I've read all that, and I just wanted to make sure I was understanding your claim that that was impairment. I appreciate your answer.
Absolutely, and to that point, even to the extent that the gender identity disorder exclusion is relevant here, which we don't believe that it is. It's a gender identity disorder exclusion except for disabilities arising from a physical impairment. And we believe that the science, as it's evolved in the past 30 years, and as the GLAD brief speaks to, shows that being trans is the result of a physical impairment. It's the result of having sex hormones that are incongruous with an individual's gender expression.
Counsel, it seems like so as I understand it, you're making two alternative arguments. The first one is gender dysphoria simply is not a gender identity disorder as used in the statute. We're not under this exclusion at all. But alternatively, if we are, it's the result of a physical impairment. So you're within the, I guess people have called it a safe harbor. It looks to me like the courts adopting that second position are saying, like, it is a plausible argument that there is a physical impairment here. We'll let this get past 12b-6, and then you'll have to prove it up on summary judgment, probably with experts. Is that, if we were to rule in your favor on that ground, is that roughly what we would be saying? You get past 12b-6, and then we'll see what happens on summary judgment?
That is certainly one option, Your Honor. That's
the only thing you get here, isn't it?
Well, the court in Doe v. Triangle Donuts, for example, went with that option to say the pleadings are too early to address this question, and a plausible reading allows. But the other issue, or the other possibility, is to settle this issue not exactly through a constitutional argument, but through an argument related to constitutional avoidance.
I thought your constitutional avoidance argument went to your first argument. This just is not within the, I don't see us figuring out whether or not this particular condition has a, results from a physical impairment or not, something on which even DSM-5 says there are indications that that is the case, but they're not prepared to say it's the case. I don't see how we reach a scientific conclusion on that without any expert testimony as a matter of constitutional avoidance.
With respect to reaching any sort of scientific answer, I completely agree with you, Your Honor. With respect to the question of constitutional avoidance, I think that this court can reach that if for no other reason than the categorical way that this exclusion only applies to people who are trans.
On that question, I'm not sure I understood your answer to Judge Quattlebaum. I thought your argument was what this statute meant when it was passed, reading the words as they were intended to be read at the time. What this meant was it covered a diagnosis that turned on being transgender itself being a mental disorder. And that is simply not a disorder, or that is not a disorder that your client has. Your client doesn't have that. She has something very different. So even understanding the words as they were intended to be used and read at the time, there's just a mismatch here. These are different diagnoses, and gender dysphoria simply does not fall within the meaning of a gender identity disorder. But I think you said something different to Judge Quattlebaum, and I want to make sure I understand what your argument is.
Sure. First of all, I believe that is an accurate representation of the argument. I believe the answer that I was providing to Judge Quattlebaum was specifically speaking to the intent, to the words as they were drafted in 1990 specifically, and the case law surrounding it. I don't believe that there has ever been a point when this law was appropriate, or for that matter, constitutional. But at the time, it did match what was in then the DSM-3 and later the DSM-4, and it was consistent with that language. Now that gender dysphoria is the appropriate diagnosis, it no longer matches that language.
So I'm still not clear. I think I'm a little thick here this morning. So your answer is that at the time that the legislation was written, it didn't allow a person who has a disorder that your client does not have to prevail.
That is correct. That said, the disorder that my client now has did not exist, at least diagnostically, at the time.
Okay.
And that.
Can I say, does your argument depend on the idea? So, and the amici briefs in this case have been extremely helpful. I thoroughly understand that gender identity disorder, as defined by DSM-3, is a different diagnosis than gender dysphoria under DSM-5. But does your argument depend on the idea that when Congress passed this exclusion in, I think, 1990, it was incorporating the DSM-3 meaning of gender identity disorder?
No, I don't believe that it does.
Cites in your brief saying.
Well, what was it doing then?
Yeah.
Well, part of the issue is that as we look back over this, it is not entirely clear what Congress exactly meant at the time. I don't think that is completely relevant here. Now that, again, that disorder is not a disorder that we've pled that our client has, but gender identity disorders in the plural, and then but for physical impairment, the amici is in their briefs and in our discussions with them and in our research on the issue, it's honestly not entirely clear what the legislators meant at the time, except that there is substantial evidence in the legislative record that these 13 or so exclusions were bundled together because there were a group of senators who felt that these things, essentially for moral reasons, should be excluded. And that's one of the reasons that we think even if this court were to look at the issue from a constitutional perspective, and even if the court were to apply rational basis review, the legislative record seems to make clear that there was never a rational basis, it was purely animus.
All right, do you have anything, you're well over time. Is there anything that you need to tell us? Or do we have?
No, Your Honor.
You sure? Questions? All right. Well, we'll still give you some time for rebuttal. We'll give the other side just as much time here. Thank you.
Thank you.
Good morning, may it please the court. My name is Philip Crone. I'm here today on behalf of the appellees in this matter, Stacey A. Kincaid, Nurse Shin Wang, and Deputy Garcia. Based on the amount of issues in this, time will be tight, but I do want to set forth briefly the issues that I'm going to talk about. Again, Ms. Williams is a transgender woman. She was incarcerated in the Fairfax County Adult Detention Center from November 16, 2018 until May 20th, 2019, approximately a 6-month period. As a result of that, she brought numerous claims against the appellees and what we're going to be addressing today that are still before the court. First, I want to address the ADA claim against Sheriff Kincaid. Second, I want to go into the 1983 claims, the deliberate indifference claim against Nurse Wong, and the equal protection claim against Deputy Garcia. In discussing those, I'll also address the Rule 15 relation back issue. Then finally, time permitting, though it's thoroughly briefed on both sides, the issues of gross negligence.
Counsel, as Judge Harris said earlier, you argue however you want, but the equal protection and the deliberate indifference claims were dismissed, as I read them, completely on statute of limitations. So, depending on what you think about that, I mean, there may be less we can do with those than others. So I just offer you that, but you argue whatever you want.
Well, depending on time, this is being reviewed de novo, and the court does have the ability to affirm or based on anything that is before it in the record.
I got you.
The ADA is discussed, qualified individual with a disability. It's a gate. That is the starting point. It's the threshold. There's no there's no argument here whether or not gender dysphoria, and specifically Ms. Williams' gender dysphoria, is a disability. It all comes down to 42 USC 12211, the exclusion statute. Gender identity disorder. That's the word that's used. It's not mentioned as being the diagnosis from the DSM. As alleged, gender dysphoria presents as discomfort or distress that is caused by a discrepancy between a person's gender identity and that person's sex assigned at birth. So gender dysphoria is a condition involving gender identity. Plain language of the statute. It's a gender identity disorder. The next issue then is whether or not it is resulting from a physical impairment, not whether it is a physical impairment.
Before we get to the physical impairment, I mean, I think there are some pretty good indications that when Congress included gender identity disorders, it did mean the currently understood disorder in which being transgender is itself a mental disease. And Ms. Williams is saying, I'm not pleading that. My gender identity is not, in fact, a disorder. I am pleading something different. I'm pleading the clinical level of stress that is associated with this disjunction between my sex-assigned birth and my gender identity, and that is different, and it is not what Congress contemplated when it included what was a term of art, gender identity disorder. There are district courts that have accepted that reasoning. Why is that wrong?
Those district courts, specifically the Blatt case out of the Eastern District of Pennsylvania, and also the Doe versus Massachusetts Department of Corrections out of Massachusetts, both of those cases in their reasoning accept that gender dysphoria falls under gender identity disorders. They do so in it. They shift, and their analysis goes into whether or not, well, specifically the Eastern District of Pennsylvania shifts and says, well, maybe
just tell me why what I said is wrong. Because we may read those district court decisions differently. So why is that not right? That's their argument. I just want to give you a chance to respond to it.
the statute reads gender identity disorders. There's no reference to it being a specific diagnosis. If you take a doctor's diagnosis, or whether it's based on the DSM or not, if it's a condition, a disorder, an impairment that involves gender identity, then it falls within that plain language of the statute. It can stop there. Then you're moving on to whether or not it results from a physical
statute as though
impairment.
what it says is disorders involving gender identity.
Yes.
Which is, okay. It's not what it says, but, okay.
Well, I'm not quite, the argument on the other side is that gender identity disorder is something very different from what they have pled. And you just say no, and we win. I mean,
They're using the reasoning from those other district court cases, being that it shifts. The gender dysphoria was a new diagnosis, so it shifted it. In that line of reasoning, if the court is looking at the DSM, the American Psychiatric Association changed the name based on the fact that they wanted to eliminate any bad connotations with it. They even say they wanted to make available legal, resources
I
and
feel
not.
sorry for, according to you, that's why they changed. But that's not, they're two different things. The disease that she is pleading, the disability that she is pleading, by definition, causes this physical symptoms. And gender dysfunction, or whatever the earlier thing was, did not. Right?
The change in it focused on symptoms. Yeah, the
there
new
wasn't
diagnosis focused on symptoms.
Go ahead.
It wasn't just a relabeling. I think they didn't just change the name so people wouldn't feel bad. It was an entirely new understanding that being transgender itself was not a disorder. Your gender identity is not a disorder. Gender identity disorder. They rejected that, and they said gender identity is not, in fact, a disorder. Sometimes there are clinical levels that follow from a disjunction between sex assigned at birth and gender identity, but that is an entirely different thing. That is I cannot convey to you how meaningful that change is. That is not a new label. It is a whole new way of understanding what is going on here.
Using that argument out of the Blatt court, they refer to that first section in the exclusion as non-disabling, and the second as disabling. It's an exclusion.
I'm not suggesting that we write down what the Black court said, so I really want to, again, use your time however you want, but we're not reviewing that decision.
So in the exclusion, you already have to meet the threshold of disability. So people who have gender identity incongruence or anything that doesn't rise to the level of being a disorder or condition that's a disability, it's not applicable, ever. It doesn't fall into the ADA yet. So changing the symptoms to focus on what makes it a disability doesn't change that there's still an exclusion for it. The definition is what describes how it affects the major activity, that substantially impacts the major activities of life. It doesn't necessarily, for example, if you buy a ticket to an amusement park, you got through the gateway, you're in. You have your child with you, she goes to hand her ticket up to ride a ride, and the attendee says, sorry, you're not tall enough. The argument on the other side is, well, I already have my ticket, so I get to ride it. The height, it's an exclusion. The statute here is an exclusion. There's no disagreement that the symptoms aren't disabling or that even they changed. Plain language, gender identity disorders. Within the definitions, you can see that there is disorder, there's incongruence, and it's involving gender identity. The analysis can stop there in the plain meaning. The allegations in this case don't reference anything about resulting from a physical impairment. There's nothing in it that suggests it always results from that gender dysphoria always results from a physical impairment. They're insufficient. The ADA claim based on that can be dismissed.
Can I ask you a question about that, about the physical impairment? So you are not arguing, as I understand it, that there is not a plausible case to be made that this condition arises from a physical impairment? You're just saying she didn't plead that?
Correct. In which case, in the other cases where it's been allowed to go on, they claim that the allegations made that claim.
Yeah, not all of them, but many of them. So can I just ask you a question? If this whole ADA claim, in your view, turns on the fact that instead of writing, I have gender dysphoria, she needed to write, I have gender dysphoria, which results from a physical impairment, why did the district court dismiss this with prejudice? I guess by default, because he didn't say it was without prejudice. Why not let her amend her complaint? I mean, that seems, I know this, we just reviewed this for abuse of discretion, but I don't understand. Like, that would just be such a formality. Why would you possibly, is it your understanding that the district court intended to dismiss this with prejudice? Because he just didn't say one way or the other.
It didn't say. Under my argument, if plaintiff has the basis to make that claim, then they would be able to replead, because it's not that gender dysphoria is always excluded. It's not, based on the language of the statute. If she could plead that it was the result from a physical impairment, then I think it, as was discussed earlier, it can get beyond the pleading stage, and then it could still be issue for proof. As
Right,
it would
but
require
if she had
exhibit.
pled that, it would escape a 12B6 motion. Is that what you say?
Yes, and if there was a basis to have pled that,
Well,
Well, but when you plead things,
of
I don't know
course.
that that's true. You get by summary judgment, yes, but.
And turning to the statute of limitations in relation back, the Rule 15 is clear. It says under C that the amended changes the party or the naming of the party against whom a claim is asserted if Rule 15C1B is satisfied, and if within the period provided by 4M for serving the summons and the complaint, the party to be brought in by the amendment receives such notice of the action that it would not be prejudiced in defending on the merits, and knew or should have known that the action would have been brought against it but for a mistake concerning the proper party's identity. The keystone here is the but for the mistake.
well, counsel, I don't think it is, because you didn't district court, but you actually argued the opposite. What you told the district court was that the relation back doctrine applies to renaming John Doe's in amended complaints when the John Doe defendant receives notice, and you cited Rumble, the sort of leading district court case by Judge Ellis,
Yes.
resolving that issue against the position you're taking today. So I think it's not just that you forfeited this argument. I think if there's any error here, it's invited. So I don't see why we can reach that question now.
Understood. As it moves forward beyond the claims, the court only dismissed, for Nurse Wong, dismissed the claims that occurred prior to February 12th based on the statute of limitations. The court also dismissed the deliberate indifference claims beyond that were still. Those involved missed hormone treatments prior to Ms. Williams' release.
So you're saying the district court dismissed the equal protection and deliberate indifference claims for reasons other than statute of limitations?
Some of them.
Not for Deputy Garcia. Deputy Garcia, the alleged incident occurred within the period that we were arguing was beyond the statute of limitations. As for Nurse Wong, there were two sets of allegations. There was the initial hormone treatments, and then there were also the furnishings of underwear, and then there's the treatments at the end of her stay in April and in May.
I don't think you've answered the question yet, though. Some of those are.
Yes, so I apologize. The court dismissed on the statute of limitations, but also dismissed on the pleadings for Nurse Wong that happened after.
But isn't it important in a deliberate indifference claim that you want to have the full scope of the conduct in front of you? I mean, does it make sense to, if we think, assuming hypothetically, we think the district court was wrong in applying the statute of limitations, don't you want to send the entire, it's one deliberate indifference claim, and doesn't the district court have to view all of the relevant conduct in deciding the claim?
Based on the pleadings, there is a separation. The pleadings allege that there were multiple treating providers. And as it comes to the treatment in April and May of the missed hormones, the allegations indicate that it wasn't just Nurse Wong involved in the treatment. There are no allegations that the mistreatments at that time resulted in any substantial harm or that there was a delay. Ultimately, there are mistreatments, and then she's released. There's no allegations that there would have been notice to anyone during that time where it could have resulted in rising to the level of deliberate indifference.
Well, hypothetically, if you had a case in which all of it was discovered together, was considered together, rather than just the end things, which you say don't evidence deliberate indifference, wouldn't that assist your general deliberate indifference case?
It could, but if we're... It isn't a single incidence, and it wasn't argued in the district court that it was a single incidence. They were divided into separate outcomes. There was a delay, treatment started, treatment was uninterrupted, then there were other issues. The argument that it was a continuing violation also wasn't raised.
Okay, let me give you a hypothetical. Suppose that somebody is in prison and you don't give them any food for 2 days, okay? That's deliberate indifference, the prison maker. Then 2 weeks, 3 weeks later, you decide that you're just going to give them very minimal food. And then 3 weeks after that, you give them 2 meals a day. And then, so do you not think that all of that would come together and have bearing on the question of whether there was deliberate indifference? No.
Those would be argued.
Okay.
In the particular scenario, it could be relevant because it's all dealing with food.
We're trying to
Now-
find out whether the actions were deliberate, whether this person was deliberately indifferent to someone else. If the answer is no, that's fine. You can go on. I don't want to stop your argument.
Can I ask you about Deputy Garcia and the search? And the district court, again, I asked our colleague about this too. I was confused because at one point the district court says, I think as to the equal protection claim, the whole thing's time barred. But then on gross negligence appears to go on, at least, I'm not sure, to reach the merits and say that there can't be gross negligence because he conducted the search pursuant to this policy. So there's some care, but as I understand the allegation in the complaint, the allegation is that the search was in violation of policy, which would have allowed for it only if there was some uncertainty as to gender, and it is alleged that Deputy Garcia was not uncertain and knew that Ms. Williams was a woman. So what is going on there? Let me give you a chance to, did the district court reach the merits, and if it did, what was it doing here?
The district court definitely dismissed based on the statute of limitations. However, the opinion does go on to address the merits, not for the equal protection, but it does do it for the gross negligence claim. And in doing so, applied the Virginia standard when it comes to gross negligence, which requires a complete lack of any
but-
actions.
But if we consider it, I mean, and that's a question, given the statute of limitations on the other, but, and I understand the argument that Virginia law requires a complete lack of care, but if the basis of the dismissal was that Garcia was following policy, and that indicates some care, and the allegations are the opposite of that, that he was not, that Garcia was not following policy, but was acting in conflict with it. I don't understand how those two, how that would, you know, how that can be evidence of some care, when the allegations, I'm not saying they're true, are that they were acting contrary to the policy.
My time is up, but may I answer
Yes.
the question?
You can take some, yes.
Thank you. The allegations related to the policies also provide an area where she's housed with the men, so she has to be searched with the men. Then there's the other policy of unless there's a question.
And what
Here-
what words you use to address, you know, Ms. Williams? I mean, the allegations about using Mr. and Sir, those were part of the allegations too, correct?
Those are part of the allegations. I read those to be more towards the equal protection.
Perhaps, okay.
Opposed to the gross negligence, but the gross negligence claim here isn't just a search with someone coming in where there'd be a question of what was happening. Here, as pled in paragraph 90, it was a shakedown. During shakedowns, officers are looking for contraband. They're catching inmates off guard. Taking the time to not do that efficiently, requiring she be taken away, escorted out, have a different person search her, it would go against the circumstances of doing a security shakedown. Based on that, there's care in following the policy. There's a male guard, the male guard searched her because she was housed with the men. There's some sort of care. And with the contradictory, the complaint alleges that the injuries or damages from Miss Williams' stay arise from the fact that she was housed improperly. That question is not before the court, and it wasn't before the district court. That there was a policy that, in that policy was improper and she should have been housed differently. Based on that allegation, the reading, again, goes with that that Deputy Garcia engaged in some sort of care. He's following rules. There's somebody housed in the male unit. They're doing a shakedown. He searched them.
Okay, when you talk about following the rules, they have to follow the federal regulations too, right? Those are the rules. Okay, well, they plead that under the federal regulations, cross-gender pat-down search should not occur unless there is an emergency, 28 CFR 1115. What about that?
Not following a federal rule under Virginia law doesn't amount to a complete neglect.
I thought you just told me that following the rules showed that you acted properly, and now you're telling me that not following the rules,
Because they're, in here, like, as I mentioned one rule, and now there's another rule on there. If he didn't follow, if there are 5 rules and he didn't follow any of them, now might be getting into a scenario where there has been complete
well, but the
neglect.
rule that you're holding up is contrary to federal law.
Which isn't at issue right now.
I beg your pardon?
None of the policies of the jail are being challenged.
Well, but they're being used as a defense. So they are challenging your use of them as a defense, right?
They are.
Yeah.
And again, in doing so, under the circumstances of a shakedown, it can't be said that Deputy Garcia didn't do anything. The bar in Virginia is high. The Elliott v. Carter case, which sets it, aren't good facts. I mean, in that case, you had a troop master giving swim lessons to kids, and then knowing those kids can't swim, brings them out into the water, multiple children, and then kids end up getting caught in the water. They can't get back. He creates enough distance where it becomes hard for him to save, but he made an attempt to save, and that's all it took. He standing somewhat near the children he knew couldn't swim, that he allowed to go out under his supervision. The bar is high. Here, the allegations don't remove all that is, leaving it that it's plausible. There was complete disregard, that nothing was done on behalf of Deputy Garcia. As I'm beyond my time, are there any further questions from the court?
All right, thank you very much.
Thank you.
You reserve 5 minutes for rebuttal, and I'm going to hold you to the 5 minutes.
Absolutely, Your Honor. Honestly, I only want to mention a handful of things. Judge Harris, I am happy that you mentioned the question of amendment. If this was simply a pleading issue, if it was simply an issue of pleading physical impairment, Judge Hilton should have granted us leave to amend to fix a facial problem with the complaint. The pleading
Did you ask to amend?
Pardon me, Judge Watts?
Did you ask to amend?
We did not ask to amend. No.
Okay.
But Judge Hilton's ruling on this amended complaint, the only substantive change, or the only change between the original complaint and the amended complaint, was to replace the John Does. So this was the first ruling substantively on the complaint. And as the court noted, Judge Hilton does not say specifically with prejudice or without prejudice, but in litigating a lot of cases in front of Judge Hilton, my experience is that if he wants to give you leave to amend, he says out loud that you're being granted leave to amend. I also wanted to return to the question of pleading physical impairment. One, again, we could have added that, although I do added that more clearly, but I do think we did plead physical impairment insofar as we pled that Ms. Williams was on hormone therapy, which is to address the physical basis for her gender dysphoria.
So am I understanding right? I mean, are you taking the position that it wasn't actually necessary to plead physical impairment because like we pled the disorder and the disorder does in fact result from a physical impairment. So once we pled the disorder, everybody knows that there's a physical impairment at root? Or are you taking the position that you did need to plead it and you did? And/or if you didn't, you should have been allowed to amend?
We are absolutely taking the first of those positions, Your Honor. That said, even if the court found that physical impairment was necessary, I also believe that we pled that. Mr. Crone mentioned that the policies were not being challenged here. And I don't think he's technically incorrect about that. But in the pleadings, the policies are used to show gross negligence and I believe deliberate indifference as well.
Yeah, on that point, I thought you were very much, the policies were part of your arguments, that the housing decision based solely on the absence of genitalia surgery, I thought you were challenging that directly, at least as to Kincaid.
Yes.
Yeah.
I thought that too.
We absolutely believe that those policies are improper.
Did you plead it?
What we pled is that those policies go to Sheriff Kincaid's gross negligence. That those policies that are inconsistent with the PREA regulations are speak to her grossly negligent behavior. All right. I don't think it's accurate to say that we pled a facial challenge to the policies, as much as we pled that these violative policies of the federal regulations speak to her gross negligence.
Do we have any questions?
And the last thing that I want to add is just that, and I think the court noted, but defendant appellees largely sort of hand wave away the weight of precedent on this issue from the district court. They simply say that Doe and Blatt were wrongly decided, and therefore everything that came after was wrongly decided. But I think that's an inconsistent and inaccurate view of the way that the system works. Doe and Blatt were decided, and then 10 other competent courts looked at those decisions and decided they were correct. That's how we create a weight of authority. And I don't think we can just disregard all of those opinions because they think they're progeny of something that was wrongly decided. And unless you have any further questions, I will stop as instructed by Judge Botts.
Thank you very much for your arguments. You know, usually we come down and greet counsel after argument. We're not going to be able to do that today, but we hope the next time that you're here in the Fourth Circuit, we will be able to do it. We appreciate your arguments. Thank you very much.
Thank you.
Thank you.
And we're know it's a little cumbersome.
to preserve its ability to reinstate dismissed or vacated counts in the wake of a defendant's successful appeal, the government has a number of options. The first, and by far easiest option for the government, is to include within the plea agreement an express reservation of rights. Just a clause that says, hey, if something goes wrong with this conviction, we're reserving our right to reinstate the counts. And we've seen the government do that in cases across the country, including within this circuit. If the government fails to make that reservation of rights clause, as it failed to do so in this case, the government still has a fallback option in most cases, and that is to move to reinstate the counts pursuant to 18 U.S.C. Section 3296. But the problem for the government here is that by its plain terms, 3296 simply doesn't apply, because Mr. Pettis never moved to vacate his plea or the plea agreement. Instead, just like the defendants in Fraunfelter and Transfiguration and Bunner and Molden and Sandoval-Lopez, Mr. Pettis's position has always been that the conviction to which he pled guilty, the count to which he pled guilty, was not an offense as a matter of law.
Counsel, I just want to make sure I understand the connection between your two arguments. So you're saying the government can't reinstate under 3296 because the defendant didn't challenge the plea or move to withdraw the plea agreement. But if the plea agreement had specifically reserved the government's right to reinstate, then they could have reinstated, but not under 3296?
Correct.
Just like in the air, there's a sort of a separate power to reinstate if it's preserved in an agreement.
I believe so, Your
Where
Honor.
does it come from?
It's an agreement between the parties, that they agree that if something goes wrong with the conviction, that the government gets to reinstate the counts.
So counts can be reinstated outside 3296. That is not the only vehicle for reinstating counts, is your view?
That is my understanding, Your Honor. That's certainly what the case law reflects.
So do, the Fourth Circuit vacated the judgment.
Correct.
So it vacates the judgment that dismisses counts 1 and 3 and finds a conviction by plea to count 2. Why, and we don't, there's not a lot of law exactly on what that means, or at least that I found. Maybe everyone else did, and I'll be enlightened here. But I'm trying to figure out the effect of that. Well, where do things stand when that judgment is vacated? We still have a contract, and you've talked about that. We still have the court has approved the plea agreement. Why aren't we just back, and we have it's an unpublished case called Bethay that suggests, vacature means the judgment's null and void. Why aren't we just back at the situation in the proceedings before the judgment is entered, where your client is agreed to plea, and I know your argument is there's nothing left under count 2, but the other argument is there's a lesser included offense within that. Why aren't we back at that stage and looking whether to proceed under the agreement, with the judgment now being null and void?
Well, I think the judgment is just what the judgment is. It's a written reflection of the conviction. By vacating, certainly this court, when it vacates the judgment, doesn't vacate the plea, doesn't vacate the plea agreement.
Correct.
Right? It doesn't reverse time. It doesn't, get rid of all these things that have already happened.
So why isn't your client, and I know your argument is that, I think I understand your argument about the lesser included offense. But assume I think that, that there is a lesser included offense within count 2. Why isn't your client obligated, just like the government is with respect to count 1 and 3, to plead as to count 2, and if it doesn't, he's breached the agreement, exposing him to prosecution under all the counts.
So with this lesser included offense argument that the government is relying on, spends a lot of time, all of the authority that the government is relying on for this lesser included offense notion flows from Rule 31C. 31C is a jury rule. It's a trial rule. It says that when you have a jury convict the defendant on a greater included offense, the court can impose judgment on a lesser included offense. And all the authority that the government relies on flows from that rule. There is no corollary rule in the context of a plea, and certainly not in a plea agreement. Yes, sir.
No, I want you to finish. But inherent in, I think, the way you're answering my question is that this lesser included offense is not an available option. But if you're wrong on that, are we back to the situation that I described?
If I am wrong that you can, in a plea context, have someone plead guilty to a lesser included offense that is never explained to them and not within the plea agreement, no, I think that is simply impossible, Your Honor, because pleas have to be knowing and voluntary and intelligent. And the plea agreement, I would remind the court that the very first paragraph of the plea agreement is, this constitutes the full and complete record of the plea agreement. There are no other agreements between the parties in addition to or different from the terms herein. That, to have Mr. Pettis agree to a lesser included offense, that would have changed his calculus by quite a bit, Your Honor.
And that may be right. I understand your argument that you don't think he's knowingly and voluntarily done that. I understand that. I guess my question, though, is from a just where we stand, perspective, is what I described right, that the vacatures there were left with a plea agreement that's been approved by the court, and the parties have to comply with it?
Yes, and I think what the court should have done when this court vacated the judgment was to go back and say, okay, we already have a approved, completed plea agreement here. Count 2 can't stand as a matter of law. The government has already agreed to dismiss counts 1 and 3. Mr. Pettis has already performed. He fully performed under the plea agreement. So there is really nothing to do here except to dismiss count 2 and order Mr. Pettis' immediate release. And that's what we asked the court to do.
And what about the frustration of purpose doctrine? Even if all of that is right, and so your client hasn't breached, he hasn't repudiated the plea, there are these cases saying even if no one does anything wrong, in cases like this, very similar cases where one of the conviction to which the defendant pled guilty is ultimately reversed on appeal, no one did anything wrong, but at this point, your client's sort of technical compliance with the plea agreement doesn't give the government anything, and so the whole purpose of the agreement has been undermined and the government's obligations are discharged.
So I respectfully disagree that the government hasn't received anything, and also the frustration of purpose doctrine simply cannot apply, Your Honor, when the future contingency that happened here was expressly baked into the plea agreement. What the government bargained for and what it received in this plea agreement that it drafted was a conditional conviction only.
So your argument, as I understand it, on frustration of purpose would really only apply to cases like this, these conditional plea agreements where the right to appeal an issue is specifically reserved.
That's correct, Your Honor. Yes. So even if the government...
I'm sorry, I didn't
Yes.
really understand the answer to that question.
I'm so
I'm a little behind. So the cases that are out there and a similar, the two cases that talk about frustration of purpose in the plea agreement, is it your plea agreement context? Is it your position that they're wrong?
For as in Bunner and Molden, Your Honors?
Yeah.
So in our case, Your Honor, I'm not sure exactly. I mean, Bunner and Molden go against Sandoval-Lopez. Obviously, we like Sandoval-Lopez more. But in this case, it simply cannot be said that the government's purpose was frustrated because it's not as if we have a plea agreement and then years down the road, the law changes and the defendant gets an unexpected windfall. This was a future contingency expressly baked into the plea agreement. All the parties were well aware that we were going to be appealing
But as
this
I
issue.
understood those cases, they were also awaiting a Supreme Court case, a different one.
Yes, but the plea agreement didn't expressly carve out this, didn't have the future contingency baked in that said, you get to preserve this issue, we're allowing you to preserve this issue.
Well, I thought your answer to me, and I should have been clearer about this, but when you said, no, your argument is limited to cases where this the contingency is made express on the face of the agreement, meant that you have no issue with Bunner and Mulder because those agreements were different. I mean, at least you may not love them, but the rule you are asking us to adopt today is consistent with the rule in those two cases. There's no conflict.
Yes, I would agree with that, Your Honor. Thank you. So even if the government now believes that this contract that it drafted is a poor one and the bargain that it struck gives it something less than what it was expecting, it is not the court's job, as the Tenth Circuit said in Fraunfelter, to rescue the parties from its own blunder. And it's particularly not the case when we're talking about a party, as Justice Gorsuch noted in his concurring opinion in Sessions v. DiMaia, a party as competent and capable of protecting its own interests as the federal government. And so we are asking, Your Honors, in this rare but not unprecedented scenario, for this court to vacate the district court's judgment and order Mr. Pettis's immediate release. I will remind the court that Mr. Pettis has now, as of today, served approximately 59 months in federal custody on a conviction that we contend the district court did not have the authority to impose in the first place. That is not including good time credit, and unless, of course, this court acts immediately, Mr. Pettis is inevitably going to serve an above-guideline sentence. Your Honors, I believe that we have already talked about most of the points that I wanted to discuss, so unless there are no further questions, yes, Your Honor.
Just, again, one of the things I have struggled with in this case is sort of figuring out how the 3296 argument kind of dovetails with the contract interpretation argument. And so if you are right that the plea agreement in this case bars reinstatement, does it matter whether the government otherwise could reinstate the indictment under 3296? Sort of how we, whether we agree with you or whether we agree with the government about whether or not we can treat this appeal as sort of effectively moving to vacate the plea. Does that matter if the agreement itself bars reinstatement?
I suppose it doesn't matter, Your Honor. I mean, I think the plea agreement does bar reinstatement. Our position was simply, you haven't reserved your rights to reinstate. So the plea agreement expressly says you're not going to further prosecute Mr.
I'm just saying, assuming hypothetically, I'm just trying to figure out how these two things work together. And you answered my first question, which was that even if you can't reinstate under 3296. If the agreement says you can reinstate, you can reinstate. And I'm asking you, does it work both ways? If the agreement says you can't reinstate, doesn't matter. You still can't use 3296. If it says you can't reinstate, 3296 is off the table.
I would agree with that, Your Honor.
I'm sorry, it was a genuine question. That is your position.
If the agreement said you cannot reinstate under 32,
No, it just
yes.
said you can't reinstate it.
Then yes, then 3296 is off the table. I would
So
agree with that, Your Honor.
your position is, no matter what the context, the consequences are, that the agreement controls?
Yes.
Okay, thank you.
Thank you, Your Honors.
Ms. Brown?
Good morning. Thank you. Lucy Brown for the United States. May it please the court. We've gotten away from this a little bit this morning, but I want to be very clear about one necessary precondition to the defendant's argument. The defendant has as a deal breaker, as the basis of its argument, that this court on remand in the original case simply vacated count 2. that's mentioned many times throughout their briefing, that this court vacated count 2, and that's why their argument stands. It's simply not what happened, however, and that's an important foundational detail for the rest of this argument. As Judge Quattlebaum brought up during my colleague's argument, this court vacated that judgment. And vacating that judgment vacated count 2, but also vacated the dismissals on counts 1 and 3.
Do you have our order? Is it in the record?
It is, Your Honor.
Can you tell me where it is?
Yes, Your Honor. JA 175 is the order.
Okay, thank you.
You're welcome. And it says that the court vacates the district court judgment and remands the case for further proceedings. And it says that without full briefing and without oral argument, because that is what both parties asked for. The defendant, in its brief, in its reply, in its supplemental brief, each time asked for vacator of the judgment of conviction in this case, the judgment and the sentence.
So do you,
Does it say end the sentence?
It does. In 3 times in the original appeal, that's what Ms. Lyston asked for. And knowing that, that's what the government agreed to. So when this case came back, the entire judgment had been vacated. So then the question becomes, what do we do with that? But all 3 counts at that point are live counts because nothing has been dismissed and nothing has been convicted. So then we have to look at where this plea agreement stands, knowing that these counts are all essentially revived by the nature of that vacator.
but the plea agreement is still in existence?
At that point it was, Your Honor. It was the defendant's next step in moving for immediate release that the district court judge took as a repudiation of that plea agreement. And that's why originally
But that's wrong. The defendant wants the benefit of the plea agreement. He wants to enforce the plea agreement. He doesn't want to repudiate it.
I think perhaps that's why the district court said that, is because the defendant wants what it wants from the plea agreement, but not what it doesn't want. And I think perhaps the district court took that as a repudiation of the plea agreement.
Seems like both parties may be doing that a tad here.
I think both parties want what they bargained for, and that maybe that changed somewhere along the way.
So if you could, I'd asked your colleague about the situation I think that you bring us to right now. The judgment's vacated. We have the plea agreement. I appreciate your position that the defendant's request for release is inconsistent with your view of the plea agreement. She would contend that it's only inconsistent if the lesser included offense under count 2 can be the basis of the plea. And she says that's not knowing and voluntary. What's your response to that?
I have a few responses to that, and I'll answer the substantive one first, but then I think there are other ways that that plea plays out the way that it did. First, as Judge Dever said in that case, when Mr. Pettis admitted that he committed count 2, he inherently admitted he committed 2 federal crimes. One, at the time, was a crime of violence while having failed to register, but the other is that he failed to register. And as the district court noted in his order, that understanding was the reason he accepted the plea as written, because he knew, just as the government did, that he had also admitted he committed that lesser included offense. And that cannot have a conviction under Section D without that admission of Section A. I think as well there are a couple other ways, though, that the district court got to this position to say the plea agreement isn't doing any work. It's unworkable at this point for a couple of other reasons. One is that the defendant was rejecting, under the district court's interpretation, but certainly just on the face of its motion for immediate release, the defendant was no longer admitting any guilt to any offense, admitting any ability to be incarcerated to any offense, was not admitting to any crime. Without that, and with the vacator of the judgment and sentence as defendant requested, it's as if there's been no sentencing. There's no conviction in the record, there's no judgment, there's no sentencing. And without a sentencing, the government cannot then fulfill its promise to dismiss counts 1 and 3, which it would only do with knowledge that it had a secure conviction for this serial violent sex offender. So without that sentencing, the government can't fulfill its promise, and they're essentially at a stalemate.
Counsel, I understand what you're saying, but just the sentence you just said about the government would not dismiss 1 and 3 without its knowledge that it had a secure conviction on count 2, then why did it sign this plea agreement, which said specifically, you're going to be appealing on count 2? And let me also say, at this time, right, the law was, that was a serious appeal. The law was moving in a defendant-friendly direction on that issue. The appeal is on the face of it, and on top of everything else, we've just decided Adams, in which we at least raised some pretty serious questions about whether the government will be able to reinstate the convictions on 1 and 3 if defendant is successful on 2. And in light of all of that, you didn't write into the agreement, this, just what you just said now, this conviction needs to be secure, and if this conviction is overruled, we are not dismissing 1 and 3. We will reinstate those counts.
So at bottom, I think it's the government's understanding of the risk it was taken, which is something we've certainly discussed a lot in this context of a bargain for exchange. The government's risk was that this may not be a crime of violence. The government's risk was not that this serial violent sex offender walks free without a federal conviction. That's why
But aren't you limited then to what you can get out of count 2? I mean, it seems to me, unless, when we vacate the judgment and you go back to the situation where the agreement's intact, has been approved, I don't see how you can, have the benefit of count 1 and 2 because of the results of the appeal, 1 and 3 because of the results of the appeal, because you knew or should have known that was a risk. But you should have the benefit of the agreement as it relates to count 2. And it seems to me the question I have is, did, with count 2 remaining, can we consider the lesser included offense, number 1? And number 2, did the defendant, in effect, breach the agreement by refusing to plead to that count?
And I should be clear, and I appreciate your question to give me the opportunity. If the defendant had come in upon remand and said, we're pleading guilty to the lesser included in count 2, the government would have moved to dismiss counts 1 and 3 as it agreed
But
to.
it's such an unusual case, because if the defendant, because the lesser included is count 1, and the defendant said, I'm not pleading guilty to count 1. So why would the defendant walk in and say, okay, I'll plead guilty to count 1, but we'll call it count 2?
I think part of the issue here, and it's actually something that was an effort at benevolence to the defendant in the plea negotiation stage that's now being weaponized against the government, is the sense that count 2 is a consecutive sentence. So there was a substantive reason, and it actually went to benefit the defendant, why that plea would not be to counts 1 and 2. And partially, I would assume, having not obviously engaged in negotiations with the defendant myself, induced a plea agreement by saying, we won't make you plead to counts 1 and 2. You won't have this consecutive sentence where you know you're getting an extra 5 years on top of whatever you get on count 1. I think that's why count 1 was not originally part of the plea agreement. Not because of any substantive reason that the defendant wasn't guilty of it or wasn't inherently admitting his guilt to failure to register when he pled guilty to count 2. Getting back to your...
But none of that is in the plea agreement, right?
I'm not sure I agree. I think partially the language of the conditional plea itself speaks to this. First of all, it is a plea count with a lesser included. The plea term itself, that conditional term, speaks in terms of counts 2 and 3, that's what the defendant can appeal, which I think a fair reading of that is that the defendant's argument as it stands now is that count 3 is dead on arrival on appeal. It has no standing, it's done. And if that's the case, I don't know why they would agree that they need to dispute counts 2 and 3 if there's no chance of count 3 being revived by appeal. I think their briefing also supports this, where throughout it argues about counts 2 and 3. If by their argument count 3 was gone and could never be revived, there would be no need to specifically litigate count 3 as well. To the other question that...
Can I ask you a question about sort of, I guess, the premise here, which is that when we vacated the judgment, that meant we also vacated the dismissal of counts 1 and 3. I'm just thinking about our Adams case. If it were clear that when we vacate a conviction in a case like this, we also vacate the dismissal of the counts that the government agreed to dismiss as part of the agreement. Why all that conversation in Adams about, the government saying, would you please specifically reinstate those counts? Doesn't that sort of indicate that they don't just kind of spring back into life when we vacate a judgment?
I'm not sure, I haven't read each of the briefs in Adams. I do know that the decision in Adams was more specific. It wasn't with remand, it was judgment in favor. I think in this case, that may be another instance where trying to sort of get along, the government maybe is now, did something that's coming back to hurt it, and that agreeing to remand, we didn't have this conversation. We didn't have this discussion.
Is there like specific authority that says this, that when we vacate a judgment, there's nothing really on point here, right? There's nothing, and I just thought that a judgment was, that our mandate on appeal is sort of limited to the issues that were appealed, so that when, I'm just struggling to understand how vacating a judgment can do work on issues that were not appealed.
And I think that's part of why the defendant's insistence on litigating counts 2 and 3 is important, because it does show the defendant thinks that these are still live issues. If the defendant's position was that count 3 is gone, never to be reinstated.
But I mean, isn't the other way to look at that, just as a matter of contract principles, that the defendant is being super careful here, and sort of doubly protecting itself, and again, whereas the government did nothing to protect its rights?
I also think that we can look at the relief sought by the defendant. The defendant knows how to ask for vacator and immediate release. She did it in this case. That's not what was sought at that time. In the original case, the relief requested was the judgment of conviction and sentence. That's what was sought. That's what the government was going off of when it agreed to a remand in this case. I don't think that would have happened if the defendant phrased in their appeal the relief they now say for the first time on remand that they were afforded by that. And unfortunately, by agreeing to that remand, we did not have the opportunity to litigate that, which wouldn't have happened if the defendant had been clear about what they were then going to interpret.
I thought the government moved for remand.
Yes, we did. Based on the defendant's assurance that they were seeking vacator of the judgment of conviction and sentence, we agreed to a remand with the understanding.
No, you moved for a remand.
I'm sorry. Yes, Your Honor, with their consent. Yes, we did move. I'm not trying to say that we didn't. I'm saying, I'm sorry, that by moving for remand, we were essentially assenting to their position that vacator of the judgment was appropriate.
Did they, was there a consent? Or was
I believe it said without objection. I can't remember if it said without objection or with consent, but the language is exactly what the defendant requested, which is vacator of the judgment.
But the motion did say that the conviction on count 2 must be vacated. I mean, I just think if well, once again, you don't need me to tell you how to do your job, but you probably, if it was important to the government, particularly in the absence of any case law directly on point, that it be well understood that although what they were arguing for was that the conviction on count 2 must be vacated, that if we were to then vacate the judgment, that would also get rid of the dismissal of 1 and 3. Probably better to have said so somewhere.
I think that we thought that was understood because the face of the judgment contains the conviction.
How could it be understood? We just had the Adams case where it clearly wasn't understood. And there's no case law saying that. I'll just use myself. I don't clearly understand it to this day, so.
Our understanding was that a vacator of a judgment nullifies that judgment. That judgment ceases to exist, and that judgment in this case did not just convict defendant on count 2, it also dismissed counts 1 and 3. The Adams case was fully litigated, it was fully briefed, it had oral argument, where these issues were teased out. In this case with remand, by moving for remand on the same relief requested by defendant, we did not have that opportunity. At the time, we thought that was a reasonable, collegial thing to do, but in retrospect, perhaps we should not have agreed to that remand, so we could have flushed these arguments out more, but I don't think it changes the substance of those arguments. As to Your Honor's earlier point, I want to be sure I answer about the fact that this was a litigated area of law at the time that this was agreed to, and it certainly was. No one could say it wasn't. That was understood by everyone. But I also think because it was being litigated doesn't mean that any particular conclusion is a foregone conclusion.
Sure, it wasn't foregone. I guess, I mean, there are all these, maybe it's just from my knowledge, there are all these cases where the government writes into the agreement, if you are successful on this appeal, we reserve the right to reinstate. All of which I think you think is probably unnecessary, but that's fine. People can, just as the defendant may have here, doubly protect themselves. Why didn't that happen in this case? Is there some, like, rule of thumb about when you do that and when you don't?
I'm not sure, but I will say, I wonder if a difference is, and I'm not sure the cases Your Honor is referring to, but I'm wondering if a difference is a lack of a lesser included, that perhaps that's the issue is, and this is discussed in some of the case law, if the counts that you then want to reinstate require separate evidence, require other proof that has necessarily not been established by a plea to this count, that's a different animal than a plea in which the count in the plea has a lesser included.
This is so, again, I'm just using myself. I was unaware of this thing where when you plead guilty to one offense, if that gets reversed, you now have to plead guilty to a lesser included. And the only case I could find on that says, no, that's not right. You don't have to do that. So is there some body of case law out there that would make this well understood for the government?
What the
other
understanding,
judges?
sure, in the briefing and in the district court's order is the case law about lesser included offenses, where we don't have anything beyond what we've put in there. But I also think we don't just have to rely on this lesser included. We also get into
Just
this.
told me that the whole thing turned on whether there was a lesser included or not. That's why I asked.
I think the whole thing turns on whether or not that plea agreement stands. But I think that purpose was frustrated as well.
Oh, I'm sorry, I thought you were telling me that when the government writes in,
Apologies. Yes, Your Honor.
and I was sort of surprised to hear that, given that there does not appear to be one case in the whole world adopting that theory.
I think that, yes, Your Honor, as I was changing topics a little bit, and I should have been clear about that. I do think probably the distinguishing factor in this conditional plea was that there was a lesser included, as opposed to completely separate counts. I don't think the outcome of this
Okay,
case.
is that written down anywhere?
I don't have
I
that.
mean, I was floored when that was the rationale of the district court.
I don't have that, Your Honor, beyond what we have
Did
in
you
our.
argue that to the district court then?
The original request was that this be considered a lesser included offense. That was the government's first tactic upon remand for just a clean and efficient resolution. The district court, I believe, thought that was a sufficient, and he was relying on Santabello, thought that was a sufficient
Yes.
explanation, but also because the defendant had then acted in a way that he interpreted to be a repudiation of that plea agreement.
Why wouldn't at that point, I mean, Rule 11A2 says in a conditional plea that the defendant has the right, if he or she's successful, to withdraw a plea.
Yes.
It seems like we kind of got off the rails because no one said, all right, we did a Rule 11 plea, here's what happens when this occurs. Are you withdrawing your plea or not? And it just seemed that had we kind of taken a step there, some of these issues would have been framed differently. And it seems like we just kind of went off in ways that we're all trying to reconstruct now.
Yes, Your Honor. I wish that had been asked. I think that is the relief that is afforded under 11A2 is the opportunity to withdraw your plea. It's not.
Then we wouldn't have to be saying is moving for release, which is a valid legal position, is akin to withdrawing a plea, or is it saying, no, I'm just trying to comply with the agreement? Anyway, that's the frustrating part to me, is that we don't have a clear articulation anyway. You've won an appeal, 11.2A has a procedure, what are you doing?
Yes, Your Honor. I do think it's important that is the relief under conditional plea. The relief is not immediate dismissal and walk out of jail. The relief is you can withdraw your plea. That was also part of the understanding in a conditional plea. I see that I'm out of time.
But he or she, the defendant keeps saying that he doesn't want to withdraw the plea. So asking this question would have been very helpful. I mean, he keeps saying, no, I want to enforce the plea.
He does to the parts that benefit him, but not the others,
Right.
which the
But
government.
you could have had an argument about all that if you had raised the issue.
Yes, Your Honor. We have to go off the record that we have. I wish that had been asked. I do think that's an understanding under 11A2, that your remedy is the opportunity to withdraw the plea. It's not immediately a get-out-of-jail-free card, so to speak. And that is the understanding in a conditional plea. That's an underlying tenet of agreeing to that term.
Can I ask a question about this Section 3296 argument? And it's kind of the same question I was asking your colleague, because I just found this mystifying. It's presented by the government as sort of an alternative argument. And I just want to make sure I understand. Is it the government's, is it your position that if otherwise this plea, for whatever reason, this plea agreement otherwise would bar reinstatement, the government can still move for reinstatement under 3296? Or does your argument assume under 3296 that there is not in effect a plea agreement that bars reinstatement?
I had not considered that before Your Honor asked that this morning, and so if that's something that deserves more careful explanation, I'd be happy to look into that and do supplemental briefing. An immediate instinct, unfortunately, goes both ways. One is you can't contract around the law, and 3296 is certainly the law. But also, as the government, we take seriously being held to our agreement. So I think if that agreement had been made, perhaps in error, because it may have been in contradiction to the law, I'm not sure I want to make that certainly.
I mean, the district court thought, and I think this is in your brief too, but certainly the district court said, look, if the defendant wanted this outcome, it should have written it into the plea agreement.
Yes.
So had the defendant put in the plea agreement signed by the government, if I am successful in my appeal, counts 1 and 3 will not be reinstated. You think it is sort of a question whether you might nevertheless go in under 3296 and say you should reinstate this.
If we had made an agreement, we would honor our agreement.
Okay, so and I gave you the easiest hypothetical, but if the defendant is right, that this agreement does in effect say that these counts will not be reinstated, then same answer. Basically, you have to be right on the contract agreement question in order to be able to go in under 3296.
I think I'm following Your Honor. Again, I would be happy to brief further if needed, but if we had made an agreement, we would honor our agreement. And I think that that's important as far as contract principles Your Honor mentioned, that this is a negotiated term. Even though the government is typically the drafter, this conditional plea term is the product of negotiation. So I don't think it's strictly construed against the government in the way that some other terms of a plea would be. If there are no further questions.
So, I'm sorry, can I just ask you, so it's your position that the question of a lesser included offense was, it's not talked about in the plea agreement, right? So, but it was known to everybody that that was a lesser included offense.
That is my
And
question.
that by definition, that had to, even if you lost on 2 and 3, in other words, if the law changed, because it was a lesser included offense on 2, you can revive 1. Is that the position?
So the reviving 1 came about separately from the lesser included. The reviving 1 came about once that plea agreement had been
I understand that.
invalidated. So as to the extent that 1 is a plea to failure to register.
When did the plea agreement get invalidated?
In the court's order, the district court's order, I believe it was in February after the remand.
So not by virtue, okay.
Not by this court's remand.
District
The
court
district
said
court.
the
Yes.
conduct post-Fourth Circuit
Yes.
was in effect a withdrawal of the plea.
Yes.
Or a failure to act that breached the agreement. Is that's, I think, how it,
Yes.
I read the district court. Is that right?
That's my understanding as well.
I don't want to cut off Judge.
Go ahead, no.
So just so I do understand your theory of this case, as I understand it, and tell me if I'm getting it wrong, is there's no binding plea agreement in this case because the defendant effectively breached it or repudiated it when he wouldn't plead guilty to the lesser included offense.
That is what the district court said in its order, and that is what we have defended to this court.
Okay, so we never get to the question of what did this plea agreement, there simply is no plea agreement. We don't get to the contract questions in this case. There is no valid plea agreement because the defendant breached it or repudiated it.
That
Okay.
along with frustration of purpose are what the district court based its decision on.
But those seem like very alternative grounds.
They are.
Which one is your position? I'm sorry, that was my question. What is your position today? What do you want us to write in an opinion?
We argued both, and I think it's appropriate to have alternative grounds, and we do that in part because to give this court options as to if one is more understandable or palatable than the other. I don't think they're mutually exclusive, though admittedly they are different.
So one is there is no plea agreement, and the other is there's a plea agreement, but the government has discharged under the frustration of purpose doctrine.
Yes.
Okay.
And the first one is only because the district court made that ruling that the defendant had repudiated the plea agreement.
That was the follow-up I had.
Yes.
It's not that there wasn't a plea agreement after the Fourth Circuit ruling.
Correct.
It was that in the post-remand activities repudiated the plea
Yes.
agreement.
That's correct. We would ask that this court affirm. Thank you.
Your Honors, I'd like to note a couple of things. First, Judge Quattlebaum, as to your question about Rule 11 and that the remedy is to withdraw the plea, that's one remedy. That's sort of giving the defendant an extra remedy, because normally you're not allowed to withdraw a plea, but they said in conditional plea agreements, if you choose, when you come back, you can withdraw the plea. But that's not the only remedy. Specific performance under Santabello versus New York is the remedy that we are seeking, because and again, I cannot stress this enough, the lesser included offense idea does not exist in the plea context. That is a jury trial rule. All of the authority that the district court relies on, all of the authority that the government relies on springs from when a jury finds a defendant guilty of a greater offense, you can then adjudge the defendant guilty of a lesser included offense. There's no corollary principle in the event in a plea context, and certainly not in a plea agreement context where everything has to be spelled out. This idea of this court's order sort of springing the indictment back into place when you vacate a judgment, I mean, if that is true, I just don't understand then why we have 3296 or why the government ever has to reserve its rights to reinstate counts, because if everything, when you vacate the judgment, everything just springs back into life and you suddenly have everything again, I mean, I struggle with it as much as this panel does, because it really is a brain teaser, but I don't, you know.
One of the questions I had is does 3296, if you read it by itself, you're almost like, this is the only way you get to go back. And if that's the issue, that leads to a very narrow set of outcomes. It doesn't sound like even you were saying that, though. You say it seems like contract trumps, or I shouldn't say that the contract isn't, or the statute isn't an exclusive way we handle this situation.
And from my reading from the case law, it seems that the government can reserve its rights to reinstate the counts. And that's one way that the counts can be reinstated. You know.
I guess, I hate to take into your reply time, but both parties are using, and the statute uses the term reinstatement, which almost begs the question of what was the effect of the judgment. And anyway, that's another area that just, I'm unsure whether the counts have to be reinstated if all that was vacated was the judgment. And that's just not logically matching up for me. I mean, if the judgment strikes the piece of paper and we still have the agreement, we still have the indictment, what needs to be reinstated as a matter of just logic?
I mean, the indictment only exists to give notice to the defendant of what the charges are against him, right? I mean, you don't need the indictment really anymore once you have the plea. I mean, the defendant can plead guilty to something that's not even in the indictment. You can always plead guilty to a criminal information.
Right.
So really, we don't even need the indictment once we have the plea and the plea agreement. And this court certainly did not reinstate or vacate the plea or the plea agreement. And I want to address my friend's argument about what in the last time in the appellate briefing that I spoke of counts 2 and 3. That was for identification purposes only, really. I mean, because our original motion to dismiss was to dismiss counts 2 and 3 because they were both incorrect. I wasn't trying to suggest that we were really attacking count 3 anymore because obviously it had already been dismissed. But for identification purposes, our motion to dismiss was the motion to dismiss counts 2 and 3. And that's how it's identified in the plea agreement. That was just the name of the motion. And Your Honors are right, we didn't move to remand this case. That was the government's idea to move to remand this case to the district court. I was preparing for oral argument. I didn't oppose the motion. I don't know of any grounds I could oppose the motion. We were seeking to vacate the judgment. I could not bring up the idea of immediate release as a relief from this court because we hadn't had that whole discussion yet about whether or not the government was going to be able to use its power under 3296 to reinstate the counts. We hadn't, the district court had not passed on any of those issues, so I couldn't ask this court for that kind of relief because I think if I had tried to do that, this court would have told me that Ms. Lyston, that issue is premature. We're not getting to that. Let's send it back to the district court. Let's see what the district court makes of it. So that's why I did not bring that up in the last appeal. Again, I would just emphasize that the lesser included offense, that is not spelled out in the plea agreement. And if that had been spelled out, and Judge Harris, to your point, it does seem, when you read the plea agreement, that seems counterintuitive. I mean, they're dismissing count 1,
Right.
Agreeing to dismiss count 1. If you wanted count 1, you could have had count 1. Oh, and as a factual matter, I just needed to say this. As it stands now, Mr. Pettis is not convicted of a lesser included offense on count 2, right? He's now convicted on count 1. So, if the theory is you can convict him of the lesser included offense under count 2, that's not what he's convicted of now. And count 1 is not a lesser included offense of count 2.
No, but the argument is, and if you prevail on whether the lesser included offense remains, I think you got a real strong appeal. I think that has to be there, and then your client's conduct repudiates that, which allows all counts then to be proceeded. So that I think the kind of, to me, the key point is there. We also have the alternative issues of the statute and the frustration of purpose. But on the contract principles, I think that's our kind of, to me at least, key point.
And our position is simply, Your Honors, that
Understood.
nothing in that plea agreement requires us to plead guilty again to a lesser included offense. He did not plead guilty to that. We have not repudiated the plea agreement in any form. And we would ask this court to enforce the plea agreement and hold the government to its bargain. Again, it's not the court's job to rescue the government from a blunder, and we would ask this court to vacate the judgment and order Mr. Pettis' immediate release. Thank you, Your Honors.
Thank you both for your arguments. It was a really a textbook example of excellent arguments, and we really appreciate it because I think this is a difficult case. I can't speak for my colleague. So we will, and we also can't come down and shake your hands. You probably both have argued here before, so you know that's our usual practice. But in these days of COVID, we don't do that. But maybe the next time you're here, we'll be able to do that. Thank you again for your arguments.
Thank you so much.
I ask the clerk to adjourn court.